Call this meeting of the Town of Clayton Board of Adjustment to order. Second item on our agenda, the adjustments to the agenda. Do we have any adjustments, staff? No adjustments to the agenda. Moving to item 3, approval of the minutes of the January 19th, 2022 Board of Adjustment minutes.
Move to approve.
We have a motion by Mr. Perricone. Do we have a second?
Second.
We have a second by Ms. Berry, maybe first. I did note one thing before you vote. If staff, under board members present, Rebecca Betty probably should be Berry, if we can make that correction. I think we knew what staff was looking for there. But, okay, we have a motion and a second. All those in favor say aye.
Aye.
All opposed? Motion carries. All right, before we move into our public hearing section tonight, we have 2 variance cases. Before we move into the first one there, I'd like to call on our attorney to go over the outline of our hearing procedures.
Thank you, Mr. Chairman. For the benefit of attendants that are not on the board, my name is Francis Raspberry. I'm the policy law firm. My firm is legal counsel to the Town of Clayton, and I'm counsel to the Board of Adjustment. Hey, Raz. Hit the button. Thank you. Getting used to the new mechanism here. Sorry, I'm Francis Raspberry, counsel to the Board of Adjustment in this matter. What we're about to begin in this hearing is what is called by statute an evidentiary hearing. The Board of Adjustment of the town sits in a quasi-judicial capacity. Quasi-judicial means court-like, and in truth, the board performs very much like a court of law in hearing cases before it, such as the 2 that have been put on the agenda tonight. The General Assembly enacted some very some comprehensive laws this past session concerning the functions of municipalities, towns, and cities in the land use and planning and zoning area. And one of the areas of emphasis was to underscore the distinction between the normal functions of towns in such matters as rezonings or adopting budgets and so forth that are in the legislative capacity of a town government. The Board of Adjustment, in contrast, sits much like a court in ruling upon applications for particular development projects or entitlements to do activities on private property that require applying evidence and facts as determined from the evidence in order to adjudicate the rights of individual applicants to either do such things, do these things, or not to do these things. Boards of adjustment have 2 functions in the town of Clayton. The first is to rule on requests for variances, and I understand both cases tonight are variance requests. And the second function is to rule on appeals from administrative determinations of the town. The basic legal principles involved in QJ or quasi-judicial hearings are to respect the due process rights of all the parties that appear before the board. The due process rights include the right to be represented by an attorney, the right to examine or cross-examine witnesses, the right to have a record made of these proceedings, the right to be represented by an attorney, and the right to appeal a decision that a party is not satisfied with to the Superior Court in this case, of Wake County. So those are the standards, or some of the standards, that are imposed on the Board of Adjustment as they hear these quasi-judicial cases. They will make their decision. In the case of variance applications, the decisions may be either to approve the variance with special, I would say, mitigating conditions, or to deny the variance. Those are the three decision options that are available to the board in these cases. The decisions will be reduced to formal findings of fact based on the evidence that is received, and conclusions of law, which is how the facts as they have found them mesh with the criteria that are statutory criteria for the granting of a variance. And in the applications that you all filled out, you'll see that there are 4 questions that are asked, and that's basically how a party outlines their case or makes or summarizes their case. And they will use those statutory criteria to guide their decision. They must find that those statutory criteria have been satisfied in order to decide that the variance should be granted in each case. The findings, the decision of the board will be reduced to formal findings of fact, conclusions of law, and an order. And according to the rules of procedure of the board, there will be a decision made this evening, more than likely, unless the cases are continued for some reason. And the final formal decision will be reduced to writing and will be adopted typically at the next regular meeting of the Board of Adjustment, when they will revisit the decision and make that final adoption of the findings, conclusions, and order in the case. So that's a synopsis of the process. Formal rules of evidence as applied in the court of law do not apply in these proceedings. I think when in doubt, the chair rules on questions of whether evidence is proper and admissible. I think the board's proceeding is to be as easy to get along with as possible, and when in doubt, to allow evidence. But there are some statutory restrictions on evidence that the board can consider, and that's one of the jobs that we have as counsel to the board, is to make a comment or to offer guidance and instructions if there are procedural evidentiary questions that come up as the hearing commences and proceeds. That's a quick summary on the process. I hope that helps a little bit. And as we move forward and hear each case, I hope to do what I can to help things go as smoothly as possible. And I'm sure every member of the board feels the same way. Thank you.
Thank you, Mr. Raspberry. Appreciate that. Before we get started tonight, I would like to go over the makeup of our board. Our board is made up of 7 members, 5 voting members, and 2 alternates. Tonight, John Tolupo is not present, so I'm going to ask that Tom Anton be a voting member tonight. So our voting makeup will be Mr. Satterfield, Mr. Perricone, myself, Mr. Anton, and Mrs. Berry. So those will be our 5 voting members tonight. So with that, we'll go to our item number 4, 4A, our first public hearing, case 2021-113, Variance Buckskin Drive Garage Variance. And I would ask for those who wish to be heard or speak on this item, please stand and be sworn in. If you would stand and raise your right hand. Anyone wishing to speak tonight on this case? Okay. Do you solemnly affirm the testimony you're about to give is true to the best of your knowledge and belief?
I do.
Thank you. And when it's your turn to come up, we'd ask that you would sign the sheet at the podium. Thank you. All right. And with that, we will call on staff to present the case.
All right, thank you, Mr. Raspberry. That was very helpful. I'm just going to open the presentation here. All right. Good evening, board, everyone else in attendance tonight. My name is Aaron Pritchard. Just going to adjust that. My name is Aaron Pritchard. I am Planner 2 in the Planning Department here in the town of Clayton. I am representing town staff tonight and presenting this variance as well as the next one. So this one is for a residential use, existing residential home at 2013 Buckskin Drive in Clayton. The property in total is about 114,000 square feet. You can see here on the first slide, it's an aerial map that I created in ArcGIS showing an aerial view of the property with a star located where the required sign was placed on the property for public noticing. This is just a slide showing exactly what element of our development code that is, applies to this case, lists the requirement under Article 3 of our UDC, so section 155.308B2. The requirement is that no accessory structure shall extend in front of the front lot line, in front of the front line of the principal structure, except in the B1 zoning district, where the Board of Adjustment may approve a variance for an accessory use or structure to be placed in any yard other than the rear yard. So the variance being requested here is for a garage, which would be partially placed forward of the front facade of the home. And just as a quick reminder, the variance, if granted, would run with the land. So should the property owner decide to move and sell the home, the variance would still apply in the case of a new owner taking over the property. This is a quick screen capture of the plot plan, which was submitted as an exhibit for the application. It shows the lot itself, as well as the home, and it also shows the proposed garage there. I apologize, it's not, perhaps not the easiest thing to see if you're in the audience, but you can see that it shows a few elements on the site. There's a riparian buffer behind the home. It's a 50-foot riparian buffer, as well as some areas of a septic drainage field and steep slopes as well. This is a street view photo of the property itself. I apologize, it's a little bit grainy. It's actually from 2008. I don't think Google has been out there recently to get a new one. However, this is more or less what the property looks like from the street. It is at the end of a cul-de-sac. Just a few things to consider. In the opinion of staff, we believe that the applicant has addressed the findings of fact. As well, Mr. Raspberry mentioned this, but I'll just reiterate, conditions may be imposed regarding location, character, and other features which may be deemed to protect property values and the general welfare of the neighborhood. So with that, I will just turn it over to, I believe, Mr. and Mrs. Lewis, the applicants and the homeowners are representing themselves. And I believe Mr. Lewis is going to come forward and offer testimony as well.
Aaron, before we do that, could I'd just like to ask the board, do you have questions for Aaron from staff before we hear from the applicant? Any questions of staff? Okay, thank you, Aaron.
Yeah.
Okay, we'll call on the applicant.
Thank you very much.
Thank you. And if you would state your name and address for the record, please.
Good evening. My name is Derek Lewis. I'm the homeowner at 2013 Buckskin Drive. Good evening, everyone. Good evening, board members. I don't have any testimony per se beyond what I put in the application, but if you have any questions, I'm more than happy to attempt to answer them.
I think it might be helpful if you maybe could summarize your the information that you presented?
Okay, absolutely. So it's my opinion. I had an appraiser, and I had someone come out and do a site survey for me. And the only place that I could put the garage, because of the EPA requirements due to my 2 ravines, is the location that I picked according to the professionals, not me. I like a garage because when I bought the home, it doesn't matter now, but the previous owner had a plan to put a home there or a garage there, and part of the purchase for me and my wife was to put that garage there. I didn't know at the time that this was going to occur, of course, so, yeah. Sorry, I'm a novice to this, so I don't really know what to say. Apologize.
Understood. All right, any questions for the applicant from the board? Ms. Perry?
Just a couple of questions regarding the garage, the outside of it. This is more a curiosity question. Are you going to match something similar to the house, and do you plan landscaping around it?
Yes, and yes. So it's going to mirror the house as much as possible, and that area is pretty trashed right now due to the woods, so I'm planning on clearing that out and putting landscaping there.
Follow up, your neighbors, I saw one attended your Zoom meeting, and he was supportive. Any other neighbor comments?
No, but we all wave and talk to each other, but they didn't want to attend my Zoom meeting for whatever reason. It was near Christmas, maybe. Wasn't a priority for them, but I put a letter out to them at the beginning of December, and I think everyone had a chance to have something to say, and they're not shy people, so they would have told me. Right. Yeah.
I had a question, according to the maps and the GIS maps and that was presented to us, and in I think the findings, there was some mention about the steepness of the area behind your house. Could you speak to that?
Absolutely. I don't know the degree by any means, but it's a straight shot down. So I live at the bottom of the hill, and the hill just keeps going down to that ravine. So my house is, the back of the house looks taller than the front of the house. My house is 2-story, but that picture, it looks like a 1-story home. So it's just a straight, I wish I had something better to describe it than a straight drop down, but that's kind of what it looks like.
Understood.
I think that I heard you say that you had some design professionals look at locating the garage.
That's correct. So originally, I thought this was a different process altogether. So I originally went with trying to get someone to build me a garage in August of last year, and that was the most leveled location that would be away from the buffer zone.
Would you say it's the only place that's feasible to place the garage on your property?
That is correct, yes. Well, at least according to the builder, not necessarily me, but to the builder, yes.
So that's what the design professionals told you? Okay.
Yes.
My other question is that, is there any reason why, what's the reason that you can't move it beyond the facade of the house?
I'm sorry, can you,
If you can, what's the reason, is there a reason why you can't place it beyond, or just scooch it back enough so it's behind the front facade of the house?
oh, so that area, I wish I had a picture. So that area is a straight decline, and on the left side, if you're facing my house, on the left side is where my septic system's at. So I can't place it there due to that. And the decline, and as soon as you get to the back edge of my house is where that buffer area starts.
Well, obviously, the buffer area was there when you bought the house, and I assume that the septic system, everything was installed when you purchased the house. So everything, all those features were existing when you purchased the property?
That's correct. Okay. That's correct. So like I said, it doesn't matter now, it's OBE now, but the previous owner was going to build a garage the same place that I want to build a garage, or similar to where I want to build a garage.
Okay, thank you.
Any other questions for the applicant?
I have a question. We keep calling this a garage, but it's not a garage. You have a 2-car garage in the front of your house, is that correct?
I do.
So this is really more a shed than a garage, correct, in front of your house?
It's going to be a garage. I don't want to say shed, because that makes me think of a little rinky-dinky shed. It's going to be a garage.
This is large enough to park a car in? Is
Yes.
that what you're saying?
Yeah, absolutely.
Okay. In the front of your house, there will be something large enough to park a car in?
I think if we look at the map, can we pull the map up? Can we pull that up? Because so when you're thinking the front of the house, you think of like in a neighborhood, like in the town of Clayton, where it's a block and it's houses next to each other. By no means will it look like that. My house is at an angle when you're looking from the street. So this area to the left where these trees are, it would be where it's at. My house is not my house is not, I guess, horizontal with the street. It's at an angle, and the garage will be off to the side of that. So it's not going to look like a shed's in someone's house, and it's going to be far enough back. If you look at the description where the wood line is, it's going to be far enough back where it's not going to look, I don't know, like in a neighborhood. If I lived in a traditional neighborhood, then of course I would, and I was my neighbor, I'd be like, no way, I don't want you to do that. But the way my land is carved out, it's not going to hurt anything. My neighbors aren't even going to see my house. The wood line's still there. The house, the garage is going to be in the wood line.
Looks like there's a concrete pad that already leads up basically where you're going. Does that look?
I'm going to the
like it's
left of it. So the previous owner had a RV, and I'm not an RV person, but I want to put a garage there instead.
That's helpful to know. And will the door of this structure face your driveway? That it will face your driveway? Okay.
Any other questions for the applicant? Thank you.
All right, thank you.
Okay, is there anyone in the audience that would like to speak for or against this case? All right. Hearing none, we'll close the public hearing and bring the discussion back to the board. Any discussion, board? I think it's one thing I forgot to mention, staff is recommending approval without any additional conditions. Is that correct?
There is a recommendation, I think that actually I agree with this. It says, if you look at page 5 of the report, page 10 of our packet, proposed accessory structure shall be built in accordance with and shall not deviate from the associated plot plan submitted as part of the variance application attached here too. I agree
Good
with
point.
that.
Absolutely. Yep. One thing I thought worth noting too, that the proposed garage does not encroach into the front or side setback, correct, Aaron? So this would just be a variance to that code section mentioned in the front of the staff report. All right, if no discussion, I'll entertain a motion.
Motion to approve the variance with the staff recommendation as I stated previously.
You have a motion by Mr. Anton. Second by Mr. Satterfield. Any discussion? Hearing none, all those in favor say aye.
Aye.
Aye. Opposed? It's unanimous. All right, moving to item 4B. Item 2021-152, variance Medspring Drive Shell variance. And I'll ask those that wish to speak on this case to please stand and raise your right hand to be sworn in. Do you solemnly affirm the testimony you're about to give is true to the best of your knowledge and belief? I do. Thank you. All right, with that, we'll open the public hearing and turn it over to staff.
All right, thank you, Mr. Chairman. Apologies for the dead air. Hello again. Presenting another variance tonight. This is for the Medspring Drive Shell property. That is located at the corner of Medspring Drive and Johnson Estate Road. It's out near the junction of the Clayton Bypass and NC 42. This is actually a lot which is part of a larger development, which is the Spring Branch Medical and Office campus. The property in total is about 2.12 acres. The variance, there's a typo up there. It says variance to the minimum parking requirement. That is not what this is for. Apologies about that. This is a request for a variance to move landscaping. There's a natural gas easement, which is along the western property line. I believe it's Piedmont Natural Gas, and that has been in place since, I believe, 2011, when this master plan, the larger master plan for Spring Branch, was approved. It actually affects this lot as well as, I believe, 2 other lots to the north. So the request is that we allow a variance for relocating trees and shrubs, which are required as part of landscaping buffers. The code, as you can see on your screen, states that the buffers shall be provided along the entire frontage abutting an existing right-of-way or adjacent parcel. So rather than requiring the applicant to place all of the landscaping plantings all the way along the buffer, the request is to allow them to relocate some of those plantings on the property to stay out of the natural gas easement. And once again, as a reminder, the variance would run with the land, so if there were a new tenant at this property, then that variance would remain in, or property owner, the variance would remain in place, if granted. This is a screen capture of the landscaping exhibit, which was submitted by the applicant. As you can see here, it shows the natural gas easement there along sort of the northwestern portion of the map. There is a required buffer along that. The applicant is requesting to move the canopy and canopy and understory trees out of that further into the property, more into the interior landscaping areas, so as to stay out of that natural gas easement. Here is a streetscape view. As you can see, it is vacant, currently undeveloped. In staff's opinion, the applicant has addressed the 4 findings of fact which are required for variance applications. Once again, conditions may be imposed regarding location, character, and other features that may be deemed to protect property values and welfare of the neighborhood in general. So with that, that's the end of my presentation. And I believe a few other people have volunteered to speak and provide testimony.
Okay, well, thank you, Aaron. Any questions for Aaron?
Just one, do we know the 2 lots that are also affected by the gas easement? Are they constructed or are they still vacant?
I believe at least one is constructed. Off the top of my head, honest, I'm not really sure what the use is there. The master plan is for some sort of medical and office use. Yeah, I'm sorry. Not really sure exactly what's to the north.
Okay, so we don't know if there was a variance request there along the same lines?
No, sir.
Aaron, I'm assuming, and just wanted you to confirm that the exhibit that you showed before, the applicant has demonstrated that those canopy trees can be dispersed on the lot.
Yes, sir. That's correct.
And the lot will accommodate the additional tree, or the trees in their new location or proposed location.
Yes, sir. That's correct. Yeah, there is enough room to provide additional landscaping where they're showing it.
Okay, thank you.
did someone verify, is the tree count, shrubbery count, everything basically generally is the same as it was required by the UDC?
Yes, sir, yes. They're not proposing any sort of reduction in plantings. It's simply just a relocation. So it's the same number that were required as part of the normal UDC requirements.
And I guess just for the record, everybody knows this probably, but the gas company would not allow those canopy trees on their easement, so that's why we're here, I'm sure.
Yes, that's correct.
Yeah. Okay, any other questions for Aaron? Okay, thank you, Aaron. Now I'll hear from the applicant. Right, right. You're exactly right. You're right.
Pardon me. Good evening, Board,
Give
Chairman.
your name and address for the record.
I'm Blair Pittman. I'm with Bobbitt Construction, here representing the owner, who is here, Dr. Matthew Flynn, and also have a landscape architect here if some of the questions get specific on the trees and landscaping
Okay.
that way.
Thank you, Blair. I think our town attorney or board attorney would like to make a statement.
Sure.
Just for clarification.
Thank you, Mr. Chairman. Just a comment that I'm bound to make. The state bar, the North Carolina State Bar, has issued an ethics opinion that appearing in a representative capacity before a local government quasi-judicial board may constitute the unauthorized practice of law. The way we typically sidestep having a problem with this bar opinion is just to ask any individual, particularly a kickoff speaker who is appearing to present the case, even though the owner of the property is here, is to ask if you would just agree and acknowledge for the record that you're appearing as a fact witness. You're not doing the sorts of things that attorneys representing clients would do, like summarizing a case, making arguments, examining witnesses, and so forth. You are appearing here just to answer questions and to testify concerning the facts that are involved in this application, if you could do that.
Yes, sir. I'm here in the capacity as a civil engineer and site planner.
Great.
For this design.
Thanks for that.
And the owner is here representing himself.
Yes, sir.
I'd be happy to have him come up and speak if that would be preferable.
I think that takes care of it. Thank you very much.
Okay, certainly. So this project, in short summary, is for a 10,000, slightly under 10,000 square foot medical office building, of which the majority of it will be utilized by Dr. Flynn for dermatology office. As noted, there is an existing 60-foot wide natural gas easement that restricts our ability to place both street yard along Johnston Estates Road and the perimeter buffer. But we are taking all the required landscaping and placing it other points on the site. There is no reduction in landscaping.
Okay.
With that summary, if there's any questions, specifics, be happy to address them.
Any questions for the applicant? Okay. Thank you. Anyone else wishing to speak? If you give us your name and address, please.
My name is Talmadge Markall. I'm 100 Dove Court here in Clayton. I am here to speak only representing the client as the landscape architect that's particular to this design. As Aaron has already mentioned, this is your basic typical code compliant landscaping plan. We didn't At the end of the day, and he's already stressed it, and Blair has spoken to this as well, it's not that we're looking to reduce the number of plantings. We're simply asking you to allow us to relocate the number of plantings that are required. We took a good hard look at the easement where it's located and the lay of the land itself, and the design that we came up with, we feel is the best design to accommodate relocating the plants. The smaller plants would be on the north side along the property line that abuts the adjacent property that's not part of this planned development. It would still act as a parking screen because those shrubs get to be about 5 foot tall. And typically, as someone in a car, that's going to be a good buffer or a good screen for them from the parking lot. The canopy trees, unfortunately, again, as was mentioned, the pipeline people, they're not going to allow a tree. Actually, they're not going to allow much of anything in their easement. So we had some space along Medspring Drive that we could squeeze one island tree in. And when I design, I typically try to account for the trees' ultimate mature size. So the layout is based on what's going to give them the best chance to thrive. Some of the tree clusters may look a little tight, but realize that when I design, I use a symbol that's pretty much scaled to being close to that mature size, somewhere between 50% to 75% of that mature size. So it gives you a close physical representation of how much space the tree canopy line is going to take up. I like the layout. I think it complements the project well. It would be ideal if we could plant and the tree islands in the easement and along the back of the parking lot that's in the easement. But unfortunately, because of the easement, we can't do that. So we feel that this is our best alternative that we could come up with. And the planning department is pretty happy with it. And again, as has been mentioned, we have met the requirements for a code compliant landscape, no reductions, just relocation of plants. That's pretty much it.
Questions?
I have a question. Did you communicate with the gas company directly?
Yes.
Did they offer any resolution other than a variance?
No, but that is a question that Blair is probably better suited to answer.
They just, as part of the easement itself across the property, do not allow any vegetation in there. The variance request itself is based on the requirements of the town of Clayton. They also do not allow any plantings in the easement.
The question here is because of the natural gas company and the gas easement, and my question is, did the gas company offer any resolution other than petitioning for a variance? So a moment ago, the landscape architect stated that canopy trees could not be planted over the natural gas line. My question is, was there another solution, like not canopy trees, but perhaps some other type of buffer in that easement?
No, ma'am. They don't allow any vegetation to be planted yet.
Okay, thank you so much.
Sure.
And to continue Blair's comment on that, what we're doing is we're meeting the town's requirement, even though the pipeline, the easement doesn't allow anything. What we're doing is trying to make sure we accommodate, satisfy the town's requirements. So
I understand that. Thank you.
cool.
Yeah, thank you.
Thank you.
And hold on.
I'm sorry.
One more question. So the only question I have is whether or not, has Piedmont taken a look at your proposal here? Have they weighed in on it?
Yes, sir. They have. We had to be able to have disturbance in the easement, they had to review our plan and sign off on it.
Okay, so you already have approval from Piedmont. If the variance is granted, you're good?
Yes, sir.
Okay.
Okay, is there anyone in attendance that would like to speak for or against this project?
sure even I can read this. I just wanted to say hello.
Can
Nice
we
to
get
meet all of you.
your name and address for the record, please?
Sure, I'm Matt Flynn, and my address is 7709 Sandy Bottom Way, and that's in Raleigh, 27613. I started family dermatology 20 years ago. We have offices in Raleigh and in Apex. We are looking to expand, and we noted that Clayton has use for about 8 or 10 dermatologists, and you've got one. So we're hoping to bring 4 more. And other than that, I'm glad they can answer those questions because I certainly couldn't. Just want to say hello.
Thank you. Any questions for Mr. Flynn? Dr. Flynn? Thank you very much. Anyone else? All right, hearing none, we'll close the public hearing and bring it back for discussion from the board. All right, sounds like we're ready for a motion. I'll entertain a motion.
Okay, I'll move to grant the variance with the staff recommended condition that Exhibit A, as submitted, be a part of that variance. And I'll read: the plant material required for Class C and Class A buffers that cannot be planted in the buffer locations due to the Piedmont natural gas easement shall be relocated to the areas indicated on Exhibit A of the variance request application. This shall be shown on the site plan prior to approval of the site plan by town staff.
Okay, we have a motion by Mr. Anton. Do I have a second?
Second.
Second by Mr. Perricone. Any discussion? All right, all those in favor say aye. Aye. All those opposed? Motion carries. All right, moving to item 5, old business. Any old business staff? Any old business? Item 6, new business. Any new business? We do have some new business.
I'll just briefly provide a little bit of a staffing update. So in the planning department, I'm pleased to announce that we have just recently conditionally offered, and it's been conditionally accepted for a new development services coordinator that, if everything works out, should start towards at the end of February. And so with that, we're down to just one outstanding position that to hire, which is our planning technician, which is currently advertised for the 3rd time now. So hopefully the planning technician position, I believe it closes at the end of this week. And so we're hopeful that we'll be able to hire someone out for that, and we'll be back to full staff hopefully soon. So
it's good news. Good news. And for those of you who don't know, Ben inherited a department with a staff of maybe 1?
When I started, we had 2 planners, and they both left. I had an open position that I brought Aaron in, and then I also had lost one of our permitting specialists, and then our engineering and inspection services coordinator has also transferred to a different job in town. So ultimately, we got down to about half of the staff, and I've slowly been able to build it back up. So
No, great. That's good news.
Yep.
Thank you, Ben. All right. That brings us down to item 7, adjournment. Do I have a motion?
Well, I usually do that. I used to adjourn.
Motion to adjourn by Mr. Satterfield. Do we have a second?
I'll second.
Second by Mrs. Berry. All those in favor say aye. Aye. Opposed? Meeting adjourned.